پنل امروز ما شامل وکلای با تجربه خیلی زیادی هست. الان میخوام آقای حمید صابی رو خدمتتون معرفی کنم. ایشون از لندن به طور مجازی برای ما صحبتشون رو ارائه خواهند کرد. آقای صبی فارغ التحصیل از دانشکده حقوق تهران و دانشگاه دندی هستند از انگلستان. ایشان تخصص دعاوی بین‌المللی در بنیادهای داوری بین‌المللی و دادگاه بین‌المللی لاهه هستند و موکلین بین‌المللی ایشان شامل دولت‌های انگلستان، اسرائیل و آمریکا هست. به افتخار ایشان.
The future of Iran's judiciary. My name is Hamid Sabi, and today I will be talking about how in Iran we can set up a judiciary that can achieve the main purpose of the people, that is giving rise to the democracy feeling of the Iranian people. As a background, Iranians were the first nation in Asia to have risen against the autocratic rule of the kings and demanded justice and democracy and respect for individual rights and freedom. The movement in 1905, which in these days would be termed as pro-democracy movement, succeeded in 1906 when the king signed an edict authorizing the establishment of parliament and free elections. It is possible that Iran was the first Asian country to have a written constitution. Parliament was established and populated with representatives of the people. A fair judicial system was needed to support this fledgling democracy. The main complaint of ordinary people was the chaotic and corrupt judicial system led by the clergy, who exposed citizens to the mullahs' whims and excessive demands and corruption. From all provinces, people began sending telegrams to Tehran requesting the Bill of Rights. Eventually, a supplemental constitutional law was passed that, at least on paper, protected the rights of individuals, and in particular, equality before law and the establishment of a court system that would protect the individual rights. It was not, however, easy to wrest the judiciary from the control of the clergy. The clergy claimed to be the only ones qualified to pass judgment, and to some extent, the parliament was under their influence. The government was also careful not to cross the red lines that the clergy had set. Although the Ministry of Justice was established and the rules of procedure were adopted, the judiciary remained in chaos. Eventually, in 1925, the then Minister of Justice, Ali Akbar Davar, who was protected by his powerful ally, Reza Shah, took a bold step by dissolving the entire judicial system and setting up a new system of justice based principally on the French system. His main aim was to reduce the influence of the clergy in the administration of justice, but was careful not to spell it out clearly because he didn't want to alienate the religious groups. He allied himself with some of the strongest religious powers in the parliament, particularly Mudarris, who was the head of the clergy there, and managed to get the bill passed. The efforts of Davar and his legacy provided Iran with a judiciary that was semi-independent. As always, there were red lines that the judiciary did not dare to cross, especially during the autocratic rule of Reza Shah and also after the collapse of national government of Mossadegh in 1953 and establishment of the unchallenged rule of Mohammad Reza Shah. The judiciary generally functioned, although it became more corrupt towards the end of Mohammad Reza Shah's rule, and the red lines started moving in many directions. Nevertheless, the judiciary showed some teeth and independence, especially in 1978, just before the collapse of monarchy and establishment of Islamic Republic of Iran. With the establishment of Islamic Republic of Iran, respect for the rule of law was abandoned. the advent of the revolutionary courts and their total disregard and disrespect for the rules of procedure and rights of individuals turned the court system and Iran's judiciary into an unashamed instrument of power and terror for the regime. The mismanagement of justice during the last 45 years of the Islamic Republic of Iran is a tragic fact. The judiciary aided and abetted the criminal gang that had ruled the country and is an accomplice in all the atrocities committed by the Islamic Republic. It is a matter of regret that the movement that started nearly 120 years ago, the first in Asia, for establishment of Adalat Khane, or the House of Justice, has seemingly succeeded in achieving exactly the opposite and has generated one of the worst mishandling of justice in the recent history of mankind. The level and depth of corruption that is now endemic in the judicial system has not only deprived many people from their lives and liberty on political fronts, but also brought extreme misery and financial burden for ordinary people and in the day-to-day disputes under petty crimes. Now let's get back to the topic of this paper, the future of Iran's judiciary. Unfortunately, there's not a single part of the present judiciary that can be saved to rebuild the future judicial system of Iran. Like Davar in 1925, the entire judicial system should be dissolved and a new organization of justice should replace it. The first and foremost requirement of any judicial system, of course, is independence. It is said that the judiciary should bow to agreements and not to governments. Without an independent judiciary, without the free elections, freedom of speech, and other liberties, nothing would have any serious meaning. Democracy would not have a meaning. An independent judiciary is a backbone of every democracy. In order to secure the independence of the judicial system, there should be a complete delineation between judicial and executive power. Therefore, there should not be a Ministry of Justice as part of the executive branch that appoints or dismisses judges or those acting in judicial capacity. Such appointments, as well as day-to-day management of the judicial affairs, should be run by judges themselves. There should not be any intermingling between the judicial system and the prosecutor's office or the government. The executive branch should run the police, law enforcement authorities, and the prosecutor office. Presently, the connection between the two administrations of judges, the two administrations, that is, judges and prosecutors, is undermining our judicial system. These should be totally disconnected. There should not be any routine promotion from the office of prosecutor to the rank of judges and vice versa. These two bodies should work independently from each other. The prosecutors and their assistants should not have any judicial capacity or power. They should seek and obtain judicial approval to exercise any power of detention, investigation, and the like. Most important part of any independent judiciary is the lawyers. The independence of the Bar Association should be guaranteed, although it was guaranteed under the Independence of Bar Act in 1957, but this time it should be part of the Constitution, and it should be embedded in Constitution as the main constitutional right of the people. All the licenses issued by government allowing those who are not members of the bar to practice law should be cancelled. Denial of the right to counsel shall be punishable, and a trial taking place without the counsel being properly presented shall be null and void. The lawyers should be immune from prosecution and harassment for representing their clients. Further, all special courts should be eliminated, and ordinary public courts shall have jurisdiction on all matters. Outside the judicial power, there should be no right or authority to detain and arrest people except in cases of emergency, and even then to be approved by a judge within a short period of time, normally 24 hours. All the detention centers belonging to non-judicial organizations should be closed and disbanded. Finally, the selection of judges is of great importance. The system that was employed during the Shah's time, that elevated judges from the lower ranks, such as assistant prosecutor, to higher ranks, and then to judges, had the fundamental problem of breeding the civil service mentality in judges, who expected the rank, benefits, and remuneration to be aligned with their promotion. Thus, some became compliant and had to follow the directions set by their political masters in order to achieve the promotion. Nothing, of course, can be worse than the selection of the judges by the Islamic Republic, where totally ignorant and illiterate judges are appointed simply on the basis of devotion to the supreme leader. In the new system of justice, judges should be selected from amongst experienced and reputable lawyers. Judges should be barred from involvement in commercial transactions and shall not be allowed to join the bar as a practicing lawyer once they retire from the bench, which is most of the times a source of corruption in the system. By separating the office of prosecutor from the judicial system and making them two independent administrations, the judiciary and prosecutor office no longer have any cozy relationship that had always existed between the two offices in Iran. It was the same during the Shah time as well. Like Dabar reforms, the new judiciary should invite respected jurists, academics, and lawyers to join and set up the new judicial system. The judges cannot then be removed from their position except with proper proceedings and with parliament approval. An independent fund should also be established by the parliament, where the judge's remuneration is paid from the fund, not from the government budget. The administration of the affairs of the judiciary should be left in the hands of the judges to set up an organization to run the day-to-day affairs of the court. The judge's powers should be extended to be able to impose penalties in cases of contempt of court, including the right to detain people who offend the court. Access to the Court of Justice should be made free for every citizen. All the expensive court fees and other restrictions should be eliminated. All trials should be open to the public. The entire prosecutor file, once an indictment is issued, shall be disclosed to the accused. No one may be questioned or interrogated by the prosecutor office without the presence of his lawyer or her lawyer. We also require complete change of the legislative measures for protection of the individual rights. The future system of justice will require laws and regulations that respect individual rights, guarantees equality before law, and fair trial. Establishment of the rule of law requires that the laws themselves are aligned with the international commitment of Iran, and in particular, the guarantees that are required under the International Covenant for Civil and Political Liberties. The fundamental requirement of equality of all citizens, irrespective of their religion, political belief, race, color, gender, is fundamental to any legal system and shall be enshrined in the new constitution. These guarantees shall be without exception and without condition. The present phrases where it says except as permitted by ordinary laws or similar wordings which appear in the principles of constitution for individual liberties shall be eliminated. Initially, the new government should suspend all the laws and regulations that are contrary to our contrary to or undermine the Universal Declaration of Human Rights of 1948 and the International Covenant for Civil and Political Rights of 1966. The new government shall also declare that death penalty is abolished and no one will be murdered by the state. In order to fast-track the proceedings for investigating the crimes committed by the members of the previous regime, the new government should set down the rules of expedited proceedings, run and controlled entirely by the judiciary, dealing with these crimes by fully respecting the established norms of transitional justice, ensuring that all the accused will receive a fair trial, represented by independent counsel of their choice, and fully paid by the government. The expedited proceedings shall be applicable within a time limit not exceeding 2 years. Thereafter, all the remaining cases shall be justiciable by the ordinary courts. Government should also set up a truth and reconciliation process, similar to that of South African model, allowing members of the Islamic regime to plead for forgiveness by giving a frank, honest, and full account of their crimes. The drafting committee of experts and professors of law should be given the task of drafting legislation to replace the existing criminal laws of the country, which had gone backward 1,300 years. Finally, protection for foreign investment. An independent judiciary is the main guarantor of foreign investment. Without an independent judiciary, even the best legislative measures cannot entice foreign investors to invest in it. A corrupt judiciary can frustrate most advanced investment protection laws. The existing investment protection laws, which are mostly those inherited from the previous regime, though they can be improved, are generally sufficient for protecting foreign capital. However, without a fair and independent judiciary, no foreign investor can rely on those laws. I thank you for this opportunity to present this paper.